Hello, my name is Ruth Cabeza. I'm a barrister. I practice from Field Court Chambers in London in Gray's Inn, and I specialise in family law. I have a particular interest in international adoption law, and I recently co-authored a book with two colleagues in Chambers which is entitled International Adoption and is published by Jordan Publishing. In this webinar, which I hope will take no more than about 30 minutes, I intend to give you an overview of the key provisions of the of the Hague Convention for the Protection of Children and Cooperation in respect of intercountry adoption. Within the webinar, I will be looking to cover the objectives and scope of the Convention, to give you an overview of central authorities and their functions, to look in particular at the procedural requirements for an intercountry adoption, and briefly to touch upon the recognition aspects. The Convention we're looking at today, its full title is the Convention of the 29th of May 1993 on the Protection of Children and Cooperation in respect of intercountry adoption. It was the 33rd Convention signed up to and prepared by the HCCH, which is the Hague Conference. Each member of the European Union has already signed up to and ratified this convention, and therefore if your international adoption is between two member states in the European Union, the convention will always apply. If you are instructed to act in one of these, I would very much advise you to have a look on the HCCH's website. It's produced in two versions, English and French, and you can access either of them via the website on www.hcch.net. It's an extraordinarily useful resource and it's free to access. If you enter into the website, you will find that there is a drop-down menu on the side, and you can go into the specialised sections, one of which is international adoption. Once you're on the international adoption page, you can access the full and regularly updated status table, which tells you who is a member of the who has signed up to the convention and when. And there's the full text of the convention itself. That is accompanied by an explanatory note, which is an extraordinarily useful document giving a commentary on the origins of and the rationale which brought the convention into being in the first place, and provides full explanation of the discussions and negotiations which led to the ultimate final form of the drafting. So it's an incredibly useful guide when looking at how to interpret the various provisions of the convention. There are also responses from the member states as to how they have implemented and how they have difficulties that they've encountered and how they've overcome them in the responses to questions that were asked by surveys, and that can give you some useful insight into how each country operates and implements the provisions in their own country. And there are also best practice guides. So I'm not going to go into the full detail, but I did want to alert you to the fact that that information is out there and you can find it for free at that website. The first thing to think about is, when you're looking at an international convention, is how is that convention implemented within the member states? Well, this one has to be given effect by the member states, but it isn't automatically law in the member states. So the convention gives the member states quite a degree of freedom and latitude as to how they choose to implement the provisions, provided they do give effect to the provisions contained within it. I'm not going to go into the details of how any, including my own jurisdiction, has implemented it, but what I do want to do is look at the key provisions of the convention itself, so that you can have a guide and an overview as to how to interpret both your own provisions and any provisions of another act, and what you can expect, in general terms at least, from the other state when you're working on one of these cases. It's worthwhile, I think, always starting at the beginning, and the beginning of this convention is a preamble. The convention is then followed by 7 chapters. And what is unusual and perhaps striking about this particular convention is that it is an extremely long preamble, and I'm going to read it out for you. It says this: "The state signatory to the present convention, recognising that the child, for the full harmonious development of his or her personality, should grow up in a family environment, in an atmosphere of happiness, love and understanding, recalling that each state should take as a matter of priority appropriate measures to enable the child to remain in the care of his or her family of origin, recognising that inter-country adoption may offer the advantage of a permanent family to a child for whom a suitable family cannot be found in his or her state of origin, convinced of the necessity to take measures to ensure that inter-country adoptions are made in the best interests of the child and with respect for his or her fundamental rights, and to prevent the abduction, sale of, or the traffic in children, desiring to establish common provisions to this effect, taking into account the principles set forth in international instruments, in particular the United Nations Convention on the Rights of the Child of the 20th of November 1989, and the United Declaration on Social and Legal Principles relating to the protection and welfare of children, with special reference to foster placement and adoption nationally and internationally, which is the General Assembly Resolution 41 of 85 of the 3rd of December 1986. So that's the preamble. The first article sets out the objective, which repeats in short version some of what we saw in the preamble. And again, it's worth looking at the wording of the objects of the convention. It states that they are A, to establish safeguards to ensure that inter-country adoptions take place in the best interest of the child and with respect for his or her fundamental rights as recognised by international law. B, to establish a system of cooperation among contracting states to ensure that those safeguards are respected and thereby prevent the abduction, the sale of, or traffic in children. C, to secure the recognition in contracting states of adoptions made in accordance with the Convention. The means by which these objectives are achieved is by regulating the adoption process in both the state of origin, which is to say the state in which the child is habitually resident, and the receiving state, which is to say the country in which the adopters are habitually resident and into which the child will eventually be received for the purposes of the adoption. Each country must designate a central authority, which is responsible for overseeing and ensuring the correct administration of the state's domestic measures to implement the Convention, and to act as a conduit of information to the other states. Chapter 3 of the Convention, which contains Articles 6 to 13, governs the designation of central authorities and also sets out which of those functions can be carried out by the central authority and which can be delegated. Rather, I should say, which must be carried out by the central authority and which can be delegated. Additionally, Article 8 only allows the central authority to delegate to public authorities the task of taking all appropriate measures to prevent improper financial or other gain in connection with an adoption and to deter all practices contrary to the objects of the Convention, although it does leave it up to the individual state to determine whether or not these public bodies are judicial or administrative ones. In particular, this provision needs to be read alongside Articles 32 and 33, which together prohibit the obtaining of improper financial or other gain from inter-country adoption and prevents violation of the Convention. In relation to the other functions of the central authority, pursuant to Article 9, it is a matter for each state to determine the extent to which they are to be carried out by its central authority, by public authorities, or by other bodies duly accredited within the state. This is not an unfettered freedom, though, since Article 10 restricts the accreditation of non-public bodies to bodies demonstrating their competence to carry out properly the tasks with which they may be entrusted, and Article 11 sets out that accredited bodies must be non-profit making, staffed by suitably qualified personnel and subject to supervision by competent authorities in that state. Crucially, the Convention requires the central authorities in both states to be actively involved in the assessment and the decision-making process. The receiving state assesses the adopters, and this process is governed by Article 15. The child's suitability to be adopted is assessed by the state of origin and is governed by Article 16. Both states must approve the match before the child can be entrusted to the adopters, and the circumstances under which the child can be entrusted to the adopters is governed by Article 17. Another key aspect of the Convention is that all member states are bound by a Convention adoption order, giving the child certainty of status not only in the receiving state and the state of origin, but in any other member state that they may live in the future. Thus, by working together, the child's state of origin and the receiving state in which the adopters live are able to ensure that, among other things, no child is removed from their state of origin for the purpose of adoption unless they are suitable to be adopted. No adopter may remove a child from his or her country of origin for the purpose of adoption elsewhere unless they are suitable to adopt that child. No person or organisation will make a financial gain from intercountry adoption. No child may be placed for adoption with prospective adopters unless both states agree that the adoption of this child by these adopters is in the child's best interests. A child who is placed for adoption with the agreement of both states must be allowed to enter and permanently reside in the country of their adoptive family. And finally, measures must be available in the receiving state to monitor the child's placement and to take protective measures if that placement breaks down before the child is adopted within its jurisdiction. The scope of the Convention is set out in Articles 2 and 3, and I'm not going to read those out, but the following key points are worth noting. The scope of the Convention is determined by habitual residence and not by other legal concepts such as nationality or domicile. Article 2.1 limits the application of the Convention to adoptions by spouses or by one person, and that is not an accident of drafting. It was very carefully discussed and other words were considered, and indeed it was at one point contemplated that adoption, intercountry adoption, should only be permitted by married couples and not by single people. But ultimately that was the those were the terms that were agreed on. Having said that, if one country feels very strongly that it wouldn't be in a child's best interest to be adopted by a single person, then it's open to that country to not consent to the adoption, whether they're the state of origin or they are the receiving state. So that is the maximum that you can, the maximum combinations, either spouses or a single person can adopt. Consideration was also given to defining the term adoption, but in the end the idea of incorporating a single definition of adoption was rejected, and instead the only prerequisite to an adoption being treated as such under the Convention is that it must create a permanent parent and child relationship. And note that, provided that a permanent parent and child relationship is established, it's not necessary for the parent and child relationship with the birth parents to be extinguished, and that allows for the inclusion of limited or simple adoptions to be included within the Convention, such as exist within the French regime, for example. Article 3 defines the scope of the Convention in terms of the age of the child. In order for a Convention adoption to proceed, the receiving state and the state of origin must have agreed that the adoption should proceed and complied with all of the measures set out in Article 17 before the child attains the age of 18 years. However, it's important to note that that age limit sets an end point. It won't act to extend an earlier deadline imposed by a child's national adoption laws. So if within the state of origin a child is not suitable to be adopted after they have attained the age of 16 years, for example, Article 3 won't extend the deadline in that member state. But what it will do, if that member state allowed adoption up to the age of 21, for example, is it will limit convention adoptions to where that agreement has been given before the child reaches the age of 18. As I said, I'm not going to have time to go into detail about Chapter 3 and Chapter 4, which go into the central authorities and the accredited bodies, or the requirements for a convention adoption order. They are important provisions and you should read them if you have one of these cases. But I do want to spend a little bit more time looking at the procedural requirements which are set out in Chapter 5. Chapter 5 starts with Article 14, and Article 14 requires the adopters to apply to their country for the if they want to apply for a convention adoption. Now, I think what is meant where it says apply is apply to be assessed, not apply for the ultimate adoption order. So the ball begins to roll, as it were, in the receiving state when the adopters apply to be assessed as suitable to adopt a child. Article 9 requires the receiving state to assess a person who is habitually resident in their country who makes an application to be assessed. And I'm not going to read the whole of Article 9, but one of the key points to my view in Article 9 is the requirement that they must, and this is at 9b, facilitate, follow and expedite proceedings with a view to obtaining the adoption. So there is an expectation and a requirement within Article 9 that central authorities expedite matters. So Article 15 is the article which governs the assessment of the adopters. And I will just read that through to you. Article 15 says, if the central authority of the receiving state is satisfied that the applicants are eligible and suitable to adopt, it shall prepare a report including information about their identity, eligibility and suitability to adopt, background, family and medical history, social environment, reasons for adoption, ability to undertake an inter-country adoption, as well as the characteristics of the children for whom they would be qualified to care. It shall transmit the report to the central authority of the state of origin. So that is what is often referred to as the Article 15 report. It must be understood, though, that the list of factors enumerated in the article is not supposed to represent the limit of the assessment of the adopters. Rather, it is the absolute minimum extent of the considerations which must be taken into account before the receiving state can be satisfied that the applicants are eligible and suitable to adopt. Pursuant to Article 4, it's the responsibility of the central authority of the state of origin to assess whether or not the inter-country adoption is in the best interest of a particular child, and the central authority can delegate that task pursuant to Article 9, and the assessment must be carried out expeditiously. The content of that assessment and the report is regulated by Article 16. Again, I'm going to read you Article 16. It says this: if the central authority of the state of origin is satisfied that the child is adoptable, it shall a. prepare a report including information about his or her identity, adoptability, background, social environment, family history, medical history, including that of the child's family, and any special needs of the child. So that's the report about the child. It must then give due consideration to the child's upbringing and to his or her ethnic, religious and cultural background, ensure that consents have been obtained in accordance with Article 4, determine on the basis in particular of the reports relating to the child and the prospective adoptive parents whether the envisaged placement is in the best interests of the child. So here we see in this provision the matching which is done by the child state. It then shall transmit to the central authority of the receiving state its report on the child, proof that the necessary consents have been obtained, and the reasons for its determination on the placement, taking care not to reveal the identity of the mother and the father if, in the state of origin, these identities may not be disclosed. Now, it's important to bear in mind that the report specified in Article 16(1)(a), this report on the child, can and should be prepared by the state of origin once it's satisfied that it's in the child's best interest to be adopted by way of an intercountry adoption. It's not necessary for the state to wait until it receives the Article 15 report to do that part of the Article 16 work. However, once the Article 15 report has been received, the actual matching process is carried out under Article 16(1)(d). When giving consideration to the match between the child and the adopter, it is necessary for the state of origin to consider the report in Article 1A and, taking into account the information in that report, turn its attention specifically to the matters specified at Articles subsection 1B and C. And if, having carried out all of the tasks specified in Article 16(1), the state of origin approves the match, it must then transmit to the central authority in the receiving state all of the information contained in Article 16(2). And the totality of the information sent pursuant to Article 16(2) is generally referred to as the Article 16 report. And it's important not to confuse that report, the Article 16 report, with the assessment of the child at Article 16(1)(a). Now, once the adopters have been assessed, and let's assume that's gone positively, the child has been assessed and has been matched by the child's state of origin, and the Article 16 report has gone off to the receiving state, it's then for the receiving state to consider that information and to decide whether or not they also approve the match. And if they approve the match, they have to resolve the immigration issues and confirm that they've done that pursuant to Article 5, and they have to confirm to the child's state of origin that they have agreed. And so before the state of origin can make a decision that the child should be entrusted to the adopters, the following things must have happened, and this is what we see in Article 17. The central authority of that state, so the child state of origin, has to have ensured that the prospective adopters agree that the central authority of the receiving state has approved their decision, where such approval is required by the law of that state or central authority of the state of origin. C, this is the cornerstone to my mind of the Convention, the central authorities of both states have agreed that the adoption may proceed. And D, it has been determined in accordance with Article 5 that the prospective adoptive parents are eligible and suitable to adopt, and that the child is or will be authorised to enter and reside permanently in the receiving state. Now, the key to understanding Article 17 is to understand what is meant by the word entrusted within the context of entrusted to the prospective adopters. The explanatory note, which I mentioned at the very outset of this talk, confirms that this article is intended to regulate the placement of the child with the prospective adopters. And it's therefore curious that the article uses the term entrusted rather than placement. But it would appear from the explanatory note that the use of the word entrusted is to ensure that confusion over the term placement was avoided, and it says this: notwithstanding the persistence of some delegations all along the conference to insert the word placement in Article 17, as in other articles of the Convention, the term entrustment was maintained for the sake of clarity, and because it offers the advantage that whoever does not understand its exact meaning will try to find it out and therefore obtain a satisfactory explanation. I don't know why, but that particular excerpt of the note always amuses me. Anyway, the agreement in Article 17C is a prerequisite of the relevant adoption proceedings being able to be considered, and unless unless after exchange of all relevant information both central authorities agreed to the adoption proceeding, the child cannot be entrusted to the prospective adopters, and each state therefore has a right of veto in relation to the adoption if, in the view of its own central authority, the adoption of the child by the prospective adopters is not in the child's best interests. This short provision is how the Convention ensures that children do not fall unseen through the child protection net. The left hand always knows what the right hand is doing, and more importantly, has to be in agreement with what the right hand is doing, and vice versa. The importance of this agreement is reflected in the requirement in Article 23 that the certificate issued for recognition purposes by the state in which the adoption order is made must specify on the certificate when and by whom the agreements under Article 17, subparagraph C, were given. Now, Article 19 deals with the transfer of the child from the receiving state. Deals with the transfer of the child to the receiving state. In summary, it prohibits the transfer of the child until the requirements of Article 17 have been satisfied, and it ensures that the transfer takes place in a safe way. It's important to understand what is meant by transfer in this context. The explanatory note doesn't define what is meant by the term transfer. The question therefore arises, does the term transfer mean enter within the jurisdiction of the receiving state for any purpose, or does it mean enter into the jurisdiction of the receiving state for the purpose of permanently residing within that jurisdiction? If the answer is the latter, then a visit by the child to stay with family members in the receiving state while assessments are being carried out by the state of origin would be permitted. If the answer is the former, then any such visit, temporary in nature, would be in contravention of Article 19. The interpretation of this provision within England and Wales is to treat transfer as the point where the child permanently transfers from its country of origin to the receiving state, and when the responsibility for the child's welfare moves out of the control of the state of origin and into the hands of the receiving state. Article 20 imposes a duty on the central authorities to keep each other informed. This duty is already imposed under Article 9b, and it's implicit in many of the other provisions, and one might wonder why it's duplicated in Article 20, which says central authorities shall keep each other informed about the adoption process and the measures taken to complete it, as well as about the progress of the placement if a probationary period is required. Now, I think perhaps the reason is that by giving this duty its own separate place in one simple and short article, it casts a focused spotlight which emphasises the importance of communication at a state level and ensures that the state of origin doesn't hold on to any illusion that once the child is transferred to the receiving state, its obligations to the child are severed. Sandwiched as it is between Articles 19, which deals with the transfer, and Article 21, which defines the duties of central authorities when an adoptive placement breaks down in the receiving state prior to the finalisation of the adoption, it reminds both states that until the adoption has been finalised, they share an ongoing responsibility for the welfare of the child. Between them, Articles 20 and 21 of the Convention implicitly impose a duty on the receiving state to monitor the child's placement with the prospective adopters once the transfer has taken place and pending any final adoption order made in that country. Although it does not expressly state that the receiving state must monitor the placement during any probationary period, it does state what should happen in the event that it appears to the receiving state that the continued placement of the child with the prospective adopters is not in the child's best interests. Clearly, if the adoption has taken place in the state of origin before the transfer of the child, Article 21 won't apply, as it only covers the situation when the child is entrusted to the adopters and transferred to the receiving state prior to the adoption order being made. Briefly, to finish, I just wanted to touch on recognition and the effects of the adoption. In order to ensure that an adoption which has been granted in compliance with the provisions of the Convention is recognised in all contracting states, the competent authority in the state in which the adoption was carried out must prepare a certificate stating that the adoption has been made in accordance with the Convention, and that certificate must, as I said earlier, specify when and by whom the agreements under Article 17c were given. An adoption certified in this way is recognised by operation of law in all other contracting states pursuant to Article 23 of the Convention. The only basis for a contracting state to refuse to recognise a Convention adoption order which has been certified pursuant to Article 23 is if the terms of Article 24 are met, and this reads, the recognition of an adoption may be refused in a contracting state only if the adoption is manifestly contrary to its public policy, taking into account the best interests of the child. Now, where it says manifestly contrary to public policy, this should be read restrictively in that it would have to go against the fundamental principles of the objecting state. But even if this criteria is met, the state would still need to consider the impact on refusal on the child and must take that into account. Well, that was a whistle-stop tour. I hope that you have enjoyed this webinar, and I hope that if you do have an international adoption, you look up the details that I've referred to on the HCCH website. Thank you for listening.